Well, yeah, but it's more than that. Because what People versus Watkins says from August 11th, 2011, this is Court of Appeals number 302558 and 302559, is that when the court makes those pretrial rulings that you're not entitled to the Section 4 immunity and you can't assert the Section 8 affirmative defense at trial, that is all you're barred from arguing to the jury, that you can't argue immunity to the jury or affirmative defense. But it's still, the Medical Marijuana Act goes to your state of mind and what you thought maybe was legal or not. They can't stop you from arguing that and presenting evidence on that as long as you don't argue that you're entitled to those two defenses under 4 and 8. So this is precedent going back like 7 years, but the people still do this in cases all over the place. They did this to Don Koschminder. They tried doing it to Peter Troes. Only there they came up with a different rationale for admitting it, to Dres Geste. Whereas in this case, but like I say, Watkins.
Right here. In our case.
Yeah, but they do it all the time. And they did it to Mr. Selman. And unfortunately, in Mr. Selman's case, that they, as they usually do when it's brought up after the fact, they say it wasn't an abuse of discretion. The trial court was within its rights to stop from confusing the jury, so he was not allowed to testify about, he couldn't present evidence about the MMA, about a mistake of law, about the medical purpose for marijuana at issue, about the political debate about legalization. And at the end, as I said, he was convicted for manufacturing marijuana. He got 3 days. Fortunately, he got a very light sentence. 3 days for time served, 6 months suspension of his driver's license, costs and fines. But it's the principal fact that he was labeled a felon in the last years of his life, which is...
It may have something to the fact that the charges arose out of 2010.
Yeah.
That when he was given his Section 8 affirmative defense, they appealed to the Court of Appeals and then to the Supreme Court.
Yeah.
I have a personal story out of that, is that I was in front of the same judge, wonderful Martha Anderson, who had granted the stay to the prosecutor's office, and I was in front of her on a defendant's case where I was asking for the same relief that she granted stay to await the Harwick Tuttle case, and she wouldn't do it. Yeah. And she didn't see the unfairness in that. And ultimately, as you said, they reversed, the Supreme Court reversed, which is crazy, sent it back. And as we said, to spend 5 years tied up in the system for a man who's genuinely... I just answer this question for me. What did they prove by winning this case? Why did they fight so,
Because they hate marijuana.
Valiantly. It was such...
keep growers in the basement.
I don't understand that.
I don't know how old he was when he passed away, but the guy, they dragged him through everything that they could. Like, who should have to put up with that? Why is it the sick people?
I don't understand either. It's a victimless crime. It wastes everyone's time.
It's not a crime. Well, you are immune. You are immune. The law does not apply to you.
I agree with you.
David Radoy was the attorney of record. The problem with this case is that it's unpublished, so it doesn't have any bearing on it. But in the Section 4 setup, which David really believed was the strongest of his arguments, they ignored logic, reasoning. There's a couple cases that clearly would contradict the reason here. Let me make my case. The first one is Manuel.
Yeah.
Manuel is a case that shows that not only does it change the crazy way law enforcement is viewed and gotcha to patients and caregivers because the wet marijuana are not dried. At the time Manuel was raided, his door was open, and he was buying marijuana plants from somebody. None of those things preclude him from his immunity. The door being open, no, because the plants are being driven, and they're allowed to be driven, and that means you're allowed to transport them. So this idea that there's this, Fort Knox idea.
Yeah, but that's
they called out an explicit exception. For that
Manuel
purpose.
There's no way
in this
that you can't distinguish in there.
Yeah, they mentioned Manuel here, and they explain how they distinguish it. In Manuel, the plants were transported from the enclosed lock facility of his car, the seller's car who brought the clones over, to the enclosed lock facility of Manuel's home at the time the police officers raided him.
That was the intention. Yeah. But had the police shown up at the exact time they were walking, what difference does it make? All right.
Well, they're
Furthermore,
saying, but they're saying he didn't violate.
There is one exception, which is the transport. Just remember, if you get caught with plants outside your facility, you're fucking transporting them. I am going to throw that out there.
I understand that.
Let me say this.
There was no violation of keeping them because he was keeping them in an enclosed lock facility. And he was just transferring from one to the next. But basically, those plants were kept in a closed lock facility. And they said that Mr. Selman's keeping his plants, those 4 plants on the back deck, was not keeping them in an enclosed lock facility.
Let me say two things. Number one is that when they enacted the definition in 2012 by way of amendment to 2013, April 2013, to what an outdoor grow can or should look like, they're very specific about saying accessible only by the caregiver.
Yeah.
Whereas in the statute original language that I made, which still remains, they clearly say accessible only by a caregiver or the patient.
Yeah.
Where there's 2 individuals that are, so you make a distinction between indoor grows and outdoor grows. And the Balsma case that's always been relied upon was an opinion that came out before the amendments of 2013. And if the legislature really wanted to make only one person accessible to the plants after Balsma, they would have done so, but they didn't. They left it alone, and they limited the number for people to one person of having access to the outdoor grow. Now, with that being said, there's another case which we're aware of, which is the Horner is the middle case on it, where they say that accessibility by somebody else, an agent per se, someone that waters the plants in a reasonable, logical way, when you become a caregiver, you are not forever never allowed to leave your house, can't leave town.
Yeah.
Under the agency theory, so long as the underlying principal actor is in compliance, the person watering plants who has access to it. Now, Alan, what's your argument? That that's not what this case is about? It's about the outdoor grown accessibility or violating the outdoor definition?
For Selman, this case is about, it's kind of a quasi-indoor-outdoor thing because he had it outdoors on his back deck, but he's still claiming it's an enclosed lock facility because it was within a deck that is attached to his house. So it's kind of a hybrid type situation.
That's the wrong argument.
Well, no, the argument here was that he should have been able to have immunity because it was locked on all sides, and but it was locked on all sides, and it was, he had wooden slats up there. I don't know that the statute specifies the heights of the slats, but you're not supposed to be able to see it from street level.
I think that's a losing argument. It may not have fit the definition, but this still 2010 when it happened.
Yeah, that's at
that time it did not. There was not.
The law hadn't been amended, so the
outdoor grows
right. But he wasn't going for that. As I said, this was decided on the enclosed lock facility.
And the Section 8.
Well, yeah.
And the Section 8.
About this. What are you talking about?
Within the house, it would have been an enclosed lock facility.
Yeah.
However, I thought the better argument was that he took it outside to deal with the mites. The idea being that you're not allowed to air your plants out. If something, it's like the idea of...
go to Grow Green in Whitmore Lake. They'll give you some organic stuff. You don't have to take them out.
Why didn't they allow him to reopen the proofs on the Section 8? That would have.
That they said was an abuse of discretion. I mean, was reviewed for an abuse of discretion, and they did not find the abuse of discretion. That it was a judge's decision to do it. Judge controls her courtroom, and that was
reopening the proofs on the Section 8 would have solved this because he would have understood, and his patients would have understood that they had to testify, and he was trying to protect his patients from net in a time when they were behaving in extremely risky manners. He was afraid that they were going to raid his patients for no reason.
And the other thing was that the reason why they should have let him reopen the proofs is because Hartwick and Tuttle opinions came down in the interim, which clarified this, somewhat of a not well understood area, and he having the benefit of that, he should have been allowed to do that since they decided that's why he wasn't entitled to assert the defense. He should have the benefit of trying to correct that error. I mean, shouldn't have been a big deal, but unfortunately they're very hard.
Keep him from having a defense, and not reopening the proofs. I feel like is a substantial issue. Yeah,
I agree. But they said that they found no abuse of discretion, unfortunately. I mean, I realize that's a cop-out, and he can't appeal that to the Supreme Court now because he's deceased, but that's what
the thing that's
says.
Fucked up about it the most is that she granted it.
Originally.
She originally
Right.
granted his Section 8.
I know, and then it went up to the Supreme Court.
And then when the Supreme Court smashed it back down, she wouldn't let him reopen the proofs and redo it. It was so random.
Yeah. Well, what's really outrageous is the Court of Appeals didn't originally want to even hear it. They were just going to
Yeah.
affirm what she did.
Right.
So, anyway, this last case that we have here is February 27th, 2018, which is Patrick Joseph Grulich versus Bay County Prosecutor Office. And
Patrick.
I don't know if I said that last
Yep,
name
that's-
right.
that's-
Groula.
A little background. Does anyone know about him?
Yeah, he is a
Improper.
Yeah.
he's improper. That's right.
But so this is case number
Nobody knows what that
335811,
means.
dated February 27th, 2018. And what happened? It sounds like Jamie's still on the line.
Jamie is on the line.
Hey, Jamie. You know him?
We all know him.
All right. Anyway, so
He was a supporter of Abrogate in the beginning, and
yeah.
he
He's also a candidate for governor.
yeah,
Good,
candidate
good.
for governor.
Anyway, in September 2013, he picked up a pot case, and he was charged with possession, and the jury ultimately found him not guilty. So he filed this action against the Bay County Prosecutor's Office and a bunch of Bay County prosecutors, Jeffrey Stroud, Bernard Joseph Capolino, and Nancy Elizabeth Barushko, and charged him with various intentional torts. Unfortunately, his case got dismissed at the trial court because of governmental immunity. And,
Such bullshit, also.
correct.
Well, can you imagine if there wasn't government immunity, the government would be sued by people like him all the time?
Yes, but at the same time, when they prosecute patients when they know they shouldn't, like this, somebody has to be held accountable for the
You're preaching to the
choir.
There's such
Right.
obvious
But there's still
selective
something a little-
prosecution going on. It's really
Yeah.
tough to handle, actually.
Let me, instead of talking about how bad this case was, and it was a really bad decision, he sued improper, and he should have gone to an attorney like Michael Comorn or someone else who maybe could, who knows 42-1983, which is a federal statute where you could sue these people in federal court where they don't retain that immunity. When a person acting under the color of state law violates a person's federal rights they're entitled to under the federal Constitution, Bill of Rights, things like that, you sue them in federal court. So that way you're not suing the state court prosecutor on his home turf. And I don't know enough of the facts of this case to know if he had a federal prosecution or violation of federal rights, but you normally have 2 years after your case is dismissed to think about doing that. And I think if he'd done that, he wouldn't have lost on the grounds of governmental immunity.
You know what? He might have lost, though, at federal court because he had additional remedies remaining in state court.
Not for 42 years. You're thinking of a habeas.
Did he sue there?
You're thinking habeas. You've got to exhaust your state remedies on a habeas. But for
No,
42,
no, yeah, he sued in federal court. No, he sued in state
this
court.
is right.
He
They
sued
don't
Court
say
of claims. He didn't sue under a civil rights.
right. He should have sued under 42 U.S.C. 1983 in federal
He
court.
still would have probably lost
Yeah.
because there's an absolute immunity to the prosecutors there as well.
It's
Now, there's
still
a,
there.
There's a qualified immunity in federal court, but
Not for
it's easier to get
prosecutors.
around. You can get around it.
Not for prosecutors. For sheriffs, for police, is qualified.
Yeah, for the police, true. The prosecutors, maybe. If the prosecutor is acting totally within the scope of their employment and in a reasonable manner, yeah, they would have immunity. When they start making statements to the newspapers outside of their employment, then they lose that immunity.
Right. Is that the North Carolina?
Yeah, it's also
Duke.
one here from Oakland County. Came from about 2008 with Deborah. I think her name's Deborah Gordon is the one prosecuting it here, where she avoided Oakland County prosecutor's immunity. That was on that case where they had the facilitator talking for the girl, and she accused.
Yeah,
her
one of the
father-
reasons though was
Oh, yeah,
because they
yeah.
were in the press talking bad stuff.
Yeah, that's
And
what I'm saying. The
They
press,
lose their immunity,
right? The
when they're
prosecutor
not
loses their immunity.
acting as a prosecutor,
Right.
and then the press.
Is that
I just said that.
Corsica?
Yeah,
He had to pay.
Yeah.
yeah. He had he faced civil liability on that one.
Mm-hmm. I remember that.
Yeah, and so anyway, that's too bad that he got dismissed out of this case, which is in state court. You know, remember, folks, the house runs the table. So when you're trying to get even with them, don't go after them in their same house. If
Don't
you do
get
have a case,
screwed by the rules.
right? Always talk to an attorney first and see if you do have this situation, you probably do have a federal court case if you could find something else to sue on. Unfortunately, there's no federal right to sue to use marijuana, so that's not going to make the basis for a 42 1983 case. But if they did something else to violate your rights, like if they